Arguably, one of the more potent campaign attacks against Donald Trump is the fact that he has been convicted of 34 felony counts and is awaiting sentencing. Probably. Last night, Trump's lawyers filed a new motion asking the judge who oversaw Trump's hush money trial, Judge Juan Merchan, to throw out Trump's conviction. His lawyers cite the recent decision by the Supreme Court in which the conservative majority ruled that presidents are immune from prosecution for official acts. Trump's team is arguing that that immunity ruling effectively nullifies the jury verdict in New York. This is their argument. Some of the evidence presented at Trump's trial included conversations Trump had with aides during his time as president. And Trump's lawyers are now calling that evidence unconstitutional official acts and saying that the inclusion of that evidence taints his guilty verdict. Joining me now is MSNBC legal correspondent Lisa Rubin. Lisa, can you flesh out this argument a little bit more, and how much weight do you think it actually carries with Judge Merchan?
Well, I think, Alex, part of it carries weight and another part of it doesn't. The argument, as you just said, is that if you're entitled to immunity based on your official acts, that's not just immunity from criminal liability. You also have immunity from those acts being introduced as evidence for even the things you do that are wholly and squarely personal, like the things for which Trump was charged in the hush money verdict. And so they are saying that it was impermissible for the DA to introduce a host of evidence that dates back to Trump's time in the White House. Everything from Hope Hicks and Madeleine Westerhout's testimony about conversations with Trump to even his tweets and a government ethics disclosure that he filled out. Now, some of that is well overstated and overblown. On the other hand, they make an argument toward the back end of their brief that I think a lot of folks are overlooking. And what they're saying is the court, in their majority opinion, said that if you're going to exclude evidence or make determinations about immunity, you got to do it at the outset of the case. Obviously, Judge Merchan did not, because this wasn't the law at the time that he was approaching his trial. And now they're saying because he didn't, and because this is now the law of the land before Trump's sentencing, the whole thing has to be thrown out, not even on substance per se, but just because the procedure didn't work correctly. And that's where I think they might have a point, Alex.
Lisa, the fact that the Supreme Court ruled after the jury issued its verdict is not special dispensation here. Because Merchan hasn't sentenced Trump, this is all up for re-examination?
Yeah, and in fact, if the verdict were still on appeal, it would be up for re-examination as well. Until the verdict and the sentence are fully and squarely finalized, a Supreme Court opinion can have impact on that case. And that's exactly where we find ourselves now. I should note that if Trump's trial had started when it was supposed to in March, we might not be facing the same situation. At least they might have to interrupt his appeal or see that differently, but at least he would have been sentenced by now. But because through a variation of delay tactics, the trial didn't start until mid-April, this is where we are, given where the Supreme Court has been.
Judge Merchan has been pretty clear in his rulings, and, you know, he's ruled for Trump on some occasions. He's ruled for the special counsel. Do you have an expectation about how deferential he's going to be to this very, in my mind, problematic Supreme Court ruling that is hazy at best? I mean, do you have a sense of where he might go on this?
I think Judge Merchan is in a completely unenviable position because, as you just said, the Supreme Court opinion isn't just lawless in many ways. It's highly unclear and amorphous in others. I think that he will find that many of Trump's arguments about what constitutes an official act is an exaggeration of the Supreme Court's opinion, even taken at its most generous. On the other hand, that sentence in the opinion that says immunity decisions have to be made at the outset of a proceeding, it's very hard to see why evidentiary decisions would be different than decisions about what conduct can be charged and not charged. That's particularly the case because the special counsel tried to argue to the court, well, evidence issues can be dealt with through jury instructions or through normal appellate procedure. And the majority said, no, that's not enough. If you're immune from prosecution, that means you shouldn't have to go through the burden of all of these pretrial proceedings and trial. That's the part I think he's really going to struggle with, and he might have to hold his nose and grant some relief for Donald Trump, even if the remainder of their arguments are really a perversion of the Supreme Court's ruling, Alex.
Well, I'm assuming that if he doesn't rule in Trump's favor, Trump's going to appeal this, and then we're going to end up right back at that court with 9 justices and a 6-3 conservative majority. But what do I know? Lisa Rubin, thank you, my friend, for your time.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn. MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.